as I already said, we are very happy to have found you to talk to us about data rights, and well, the stage is yours.
Thank you very much. The pleasure is all mine. Let me introduce myself very briefly. My name is Paweł Kamocki, and I am here as a representative of Text Plus and HeFDI consortium. That's a consortium of the German national research data infrastructure that deals specifically with text data. Of course, an important part of our clientele, so to say, are language researchers specifically, but we also cater to the needs of other researchers in the humanities, social sciences, historians. My personal background is in both law and linguistics. I studied both, and then I decided to pursue a PhD in information law, and now I am working on digital infrastructure projects in language science, dealing with language data, such as Clarineric, when I am chairing the Legal and Ethical Issues Committee, and the aforementioned Text Plus, where I am co-chairing the working group on legal and ethical issues. So I am a legal scholar, and I'll be talking to you today as a legal scholar, but I mostly work with language data and linguists, so that's a particular perspective. Language data is a very special kind of data when it comes to legal constraints, so I will naturally focus on those aspects of data regulation that seem the most relevant for our community, that is the language community. All right, let's dive in. So Sherlock Holmes used to say, "Data, data, data. I can't make bricks without clay." But today, data is important not only for making bricks or doing the work of a detective, but it is also an essential resource for modern economy. The notion of data economy was coined about a decade ago, and it refers to a sector of national economy that involves data transactions and the generation, storage, processing, analysis, and exploitation of digital data. It is today a very important branch of economy, and it's a branch of economy that is predicted to grow steadily. So data is an essential resource, and if you are in the presence of an essential resource, the danger that you are facing is the so-called tragedy of the commons. This is a phenomenon that was first described in, well, it wasn't first described, but it was named in a 1968 article by the same title, The Tragedy of the Commons, and the author, Mr. Hardin, argued that where we have a valuable resource and there is a large number of people that are allowed to enjoy unlimited access to this resource, they will always inevitably end up destroying the value, depleting the value of the resource. The classic example is a pasture. If everyone is allowed to use the pasture, they will just overuse it and it will turn into a wasteland. So that's the classic way of thinking about any goods. Of course, and immaterial goods that are not really depleted with use. This is slightly different, but you can also argue that if you provide if you enable unlimited access to an immaterial good like digital data to a large number of people, there will be less investment, for example, in data and surrounding technology. So it was believed for a very long time, and by many it still is, believed that in order to optimize the value of a resource, such as data, regulation is needed. So access should be limited, and at least at the early stages of regulation of information and data, that would be in the 18th century, it was believed that monopolization is a good way to regulate access to the data. That is, allow certain actors or classes of actors to establish their monopolies in concerning certain types of information or types of data. This is, for example, how printers' monopolies came to be. But today, things, the way that things are looking today is, I think, brilliantly presented on this picture by Ingram Pin, this cartoon drawing from Financial Times. So if you imagine digital data as a place in space, a park or a pasture, nowadays there are enclosures built, fences built around large parcels of this ground, and these are actually digital enclosures. So those fences, if you look up closely, are made of ones and zeros, which of course refers to code. So large chunks of data are actually monopolized, privatized by those tech giants, and it used to be for a long time, if not encouraged, then at least enabled by the legislator. This is a little drawing of mine, a scheme that I prepared to show you that I am a sensible person who loves art and drawing. And this this gray area on the top is supposed to represent digital data. So theoretically, there is no fence around this whole area. There is no comprehensive regulation on all the data, but there are little parcels of those space that are protected by different monopolies, different legal frameworks such as copyright, the sui generis database right, trade secret, or data protection, that is the GDPR. But in front of this space, there are also huge fences that represent technical interoperability, because you may have access to data, but if for technical reasons, for lack of technical interoperability, you cannot use it, or you cannot use it fully, that's still no good access to the data. And above all, the first fence is represented by contracts, such as, for example, terms of service that frame your access to the data. So you are technically only allowed to do with the data what a contract with a service provider allows you to do. So this used to be the situation for quite a long time, until very recently, and things have started to evolve in a different direction. It's really hard to say when exactly, but I would argue that it started with the directive on the reuse of public sector information. That is a 2003 directive that was more recently, in 2019, replaced by a more ambitious directive on open data. And this open data directive was transposed in 2021, and there will be an evaluation in 2025. So maybe we can expect some little tweaks to the framework from the Commission. But this is a framework that is already quite well established and very much in place. And under this framework, documents that are held by public sector bodies and public undertakings should be made available for reuse. That is, they should be reusable for both commercial and non-commercial purposes. So there is a principle of open by design and by default for documents held by public sector bodies. The so-called public sector information, or PSI. Now, how it works in practice. So if you are interested in reusing such documents, having access to those documents, you should make a request, file a request for reuse with the public body in question. And this request is in principle free of charge, although fees can be charged to cover the costs. That sounds interesting, but it has a major flaw, major drawback in this framework is that any documents in which a third party holds intellectual property rights, and that includes trade secrets, so that's typically copyright, sui generis, database right, but also trade secret, as well as documents containing personal data are actually excluded from reuse under this framework. There are also special rules. Well, maybe let me say a word about this exclusion. So this is something that is really a bummer, if I may use the word, for the language community. The language community would be, for example, interested in documents, multilingual documents, all sorts of documents that are translated and that public sector bodies quite often have, because they have multilingual websites, or they have various forms, templates in several languages, or they communicate in the national language and in English, or in multilingual countries, they communicate in several official languages. Such multilingual human-translated, high-quality human-translated documents can be a very important resource for language science and translation science specifically. But it turns out that quite often, actually, copyright in translations is still held by the translator or the translating company. And so such translations are not available for reuse. So we cannot, if we file a request to reuse such documents, the answer will be, well, we cannot make these documents available for reuse because they are under copyright. There are also, in this Open Data Directive, there are so-called high-value data sets. These should be available free of charge in a machine-readable form via an API, application processing interface, and they should be made available for bulk download. These are the categories of data that are labeled as high-value data sets, are listed on the slide. So that's geospatial data, Earth observation and environment data, meteorological data, statistics, which is quite puzzling because, well, that's a very, very broad term, isn't it? Data on companies and company ownership, as well as mobility data, like public transportation, for example. These kinds of data should be even more available, more easily, more readily available for reuse. But this is unfortunately not something that is useful for the language community. So let me now get back to the presentation. So the second important sign of change is the directive on digital single market, on copyright in the digital single market, the so-called Digital Single Market Directive, or DSM, that had to be transposed by 2021, so it's already transposed. And this directive contains something pretty important, and these are statutory exceptions for text and data mining. Now, without entering into details, these exceptions say that if you want to mine data, that is, digitally analyze data that are protected by copyright, you don't need permission from the right holder to do so. The main condition is that you need to have lawful access to the data. So, what is lawful access? It is actually defined in one of the recitals of the directive as access with permission. If you have a license to access the data, for example, you have subscription to a journal, an online journal, or the data is openly available on the internet without any password protection, for example. Everyone can see it with internet access. That's also lawful access, but that's not a lot, right? So maybe we should add new categories of lawful access, and this is precisely what is happening. But then you cannot really say that the DSM directive was a complete game changer, because it's also a directive that established a new monopoly on data for press publishers. So both strategies are present in this directive, so to say. Then February 2020, very memorable month for many of us, the beginning of the COVID pandemic. The European Commission announced its European data strategy. A strategy that was aimed at establishing a single market for data in Europe, especially through the establishment of the so-called common European data spaces, which still is an ongoing process. And by doing so, this strategy would strengthen Europe's global competitiveness and guarantee our, that is, European data sovereignty. And within this strategy, 4 acts were first proposed and then adopted. I provide on this slide a short timeline. So these are the Data Governance Act, which is now applicable from September 23. The Digital Markets Act, that is also applicable. The Digital Services Act, that has just quite recently entered into application in February 2024. And the Data Act, the most recent one that will enter into application, become applicable in September 2025. So let me very briefly present the relevant provisions of those acts. I will not, they are really quite long, quite detailed, and quite varied, quite heterogeneous. So they contain, all of them actually contain a lot of provisions on things that may seem unrelated to one another. But I will just provide an overview, selecting those aspects of those acts that actually back up my hypothesis that we are no longer in the monopolization game, but we are in the access and right of access game. Technically, all of these are regulations, like the GDPR, which means that they do not require transposition. They just apply sort of automatically in all EU member states and even in the European Economic Area, which is slightly larger than the European Union. All right. Okay, I have a question.
Paweł, may I interrupt you myself?
Please do.
Well, thanks for giving this overview and the overview of the history evolving so far. What's a very strong question to me, and I think to many of us, is, of course, I heard the words on Data Governance Act, Digital Markets Act, etc., etc. But what I always thought is, what I was always wondering is, how does this affect us as working in the science domain? What's the relevance of, for example, the Digital Markets Act or the whole data strategy for research data and for science?
Yes, hopefully this is precisely what the rest of my presentation is going to be about. Let's start chronologically with the first one. So the Data Governance Act. What I think is quite important for research data as well is that it contains a definition of data, a comprehensive definition of data. So finally, we know what is data. So that's any digital representation of acts, facts, or information, which sort of clashes with the definition of personal data in the GDPR that only defines personal data as information, whereas data more generally is information, facts, or acts, or representations of actually acts, facts, or information. But anyway, so for the research data community, specifically what's important is that now we have rules on reuse of protected data held by public sector bodies. So those data that were excluded under the Open Data Directive because they are protected by third-party IP rights or they contain personal data are now available for reuse. So in my example, the language research community, translation research community, would like to access multilingual human translated documents from public sector bodies. They couldn't request access to those documents under the Open Data Directive, but now it is possible under the Data Governance Act. Access to such documents can be requested via single information points, but the protected nature of the document is preserved, which is interesting because it means that the documents, at least some of the documents, cannot be provided as such, but they can be provided in a pre-processed form. That is, they can be anonymized, they can be aggregated. Also, the reuser, so a research organization, may have to sign a confidentiality agreement, or the data may only be available for reuse in a protected environment, that is via dedicated portal in which you cannot take the data out of, or even in a special, so to say, data room that is on a special terminal, a special computer that has no access to the internet whatsoever. So the data remains protected, but you can request access to those data as a researcher or as a citizen. There are also new rules on intermediation services that are quite closely supervised by a competent authority. You will see that the competent authority is a word that appears a lot in this new framework on my slides, and I will tell you why in a second, why it's important. It's also very interesting for the research community that now we have a framework on data altruism. That is a possibility to donate, so to say, data for a general interest purpose, such as a research purpose. It can be donated by an individual, but also by a company, a publisher, press publisher, for example, or book publisher, can actually donate all the publications or just part of the publications for research purposes specifically. Or a hospital can sort of donate data, patient data, for medical research purposes. This is done via a special data altruism consent form, and this is organized by special intermediaries that are called certified data altruism organizations. So technically, a publisher who wants to donate data to science contacts a certified data altruism organization, gives the data, transfers the data to this organization, and then researchers can access the data via this certified organization. And this whole system is, of course, once again, supervised by a competent authority. Right. Digital Markets Act, that will be quick. It is not directly relevant for research, and it regulates the position of gatekeepers. So if you remember this cartoon drawing from Financial Times that I showed you, now these fences, maybe they won't disappear completely, but they will kind of become smaller and thinner. So this is specifically targeting 6 companies. Interestingly, none of them is European. That's Facebook, Amazon, Apple, TikTok. ByteDance is a provider of TikTok, Facebook, and Microsoft. And this Digital Markets Act contains a really complex list of obligations and prohibitions, including the obligation to enable access to and interoperability of data that they hold. What's interesting is that there are very high fines for non-compliance, going up to 10% of worldwide turnover. So if you recently saw a major change in how Facebook works, or the Messenger provided by Facebook works, this is due to the Digital Markets Act. And the Messenger specifically, things have been changed to enable portability of Messenger data. Digital Services Act, it is mostly about the liability of providers of intermediary services, so maybe not directly relevant to research, but it also contains rules on access to data from very large online platforms and very large search engines. Such very large providers are specifically listed by the European Commission, and there are, I think, 23 platforms on that list, including Facebook, of course, Twitter, TikTok, but also Zalando, which is a German, as you know, of course, German platform. And there are only 2 very large search engines, and these are Google and Bing. Now, if you are a researcher and you want to do research on data from those platforms, there is an interesting framework that is now in place and that is offered to you. So what you have to do is you have to apply for access to that data with the digital service coordinator. That will be a competent body. Last time I checked, and that was last week or 2 weeks ago, the digital services coordinator wasn't established in Germany yet. That was a bit of a delay, which is unusual for Germany, because Germany usually complies quite fast with EU law. That might have changed, but anyway, that's a competent body, an official body that you have to submit an application to, and they will examine your application and decide whether you are a vetted researcher or you can be a vetted researcher. So your application should disclose your research purposes, your affiliation, of course, your funding, and you should also convince the authority that you are capable of ensuring compliance with data protection, data security, and confidentiality requirements. And you have to carry out research on systemic risks. That's not for every research, that's for research on systemic risks, which is roughly defined as research regarding the risks related to dissemination of illegal content and risks to fundamental freedoms and public security related to the functioning of those platforms. So the digital service coordinator decides whether you are a vetted researcher, and if your application is accepted, they will actually contact the platform and request the data on your behalf, and the platform cannot refuse, basically.
Mr. Kamocki, there's
Yes.
a question in the chat concerning this intermediary service.
Oh, yeah. Official intermediation services. The European Data Science European Language Data Cloud space. I'm sorry, as part of the Common European Data Spaces for Language Data, specifically ELDC, European Language Data Space, ELDS, that would be, that has recently been established, is going to become an intermediary specifically for language data, if this answers your question. But this is still very much in statu nascendi. It's still in the process of crystallizing. But yeah, those intermediation services are specifically, those rules on intermediation services are specifically for the European data spaces. All right, so that was, I have more questions. So the Forschungsdatengesetz is, well, the point is that we don't really know what it's going to be. We only know that it will be adopted as in the coalition agreement. But to the best of my knowledge, we still don't know the exact content of this act. And this is something that is very much in line with the new optics in the European Union, that is providing access specifically to researchers, specifically for research purposes, to all data or certain categories of data, mostly from the public sector. So that's, think of it, of the Forschungsdatengesetz as maybe an addendum to those acts, something that goes a step further, is intended to go a step further in the same direction. I am really quite close to my conclusion and a drawing that represents my conclusion, and I hope that it will at least partly answer your question about what this Forschungsdatengesetz will change for researchers. All right, now the Data Act, that's the one that is not in application yet. It will become applicable in 2025. It contains rules on accessibility and portability of data from connected devices, for example, in our field specifically voice assistants. So under this framework, users of a connected device can request access to the data from the device as well as data generated by using related services, and they can also ask for this data to be transferred directly to a third party, and this third party can specifically be a research organization. So they can sort of decide one day that, well, my voice assistant data, they can be quite useful for language researchers, so I should think about donating, transferring my data from my device to a research organization or a language data space, a language data intermediary. And now it's, well, in September 2025, this will be made possible. There is also an interesting obligation for private actors, private businesses, to share data with public bodies in cases of exceptional need. This exceptional need can, of course, be public health related, like a pandemic, can be a natural disaster or a major cybersecurity incident. And if a public body needs access to certain data to address this public emergency in an efficient manner, the public body can request a business to share their data with the public body. And afterwards, the public sector body can actually decide to share this data with a research organization or research organizations, plural. There are also rules on data interoperability. That is more or less a codification of FAIR principles. There is not a whole lot about it in the Data Act itself, but it contains a delegation for the Commission, so the European Commission will be able to adopt acts with more specific rules regarding interoperability of data and services. And this is specifically, once again, targeted at those European data spaces. All right, so you remember my drawing of what the situation used to be, and I think that this is what the landscape has turned into. So first of all, as you can see, now we have more or less comprehensive regulation on data as a whole. So we have regulation around this greenish space. Those sub-enclosures, those sub-fields of data that are protected by copyright or data protection, these fences are now smaller, and also the enclosed areas are slightly smaller. The fences that represent technical interoperability and contractual agreements are smaller as well, but most importantly, there are now paths to access data, several of them, maybe more, but I chose to include the following on my slide. That is, public sector data can be accessed through a special pathway, a special framework. TDM exceptions, text and data mining exceptions, are a special pathway to use the data. Data altruism, the mechanism allowing to donate data for a public purpose, is another mechanism that opens access to the data. Trusted intermediaries play a fundamental role in providing access to the data. So once again, the data spaces. The framework for vetted researchers that I described from the Digital Services Act. And finally, the notion of exceptional need also opens a new pathway to the data. So it looks much better than the previous picture, but there is something that we should not forget, is that all those pathways are actually closely monitored by competent authorities as well as European supervisory bodies. So, for example, in order to apply for access to Twitter data for research purposes, you actually have to file a request with a competent authority, and it's the competent authority that will scrutinize your research project, so to say, and decide whether you are worthy, so to say, of access to the data. Now, we don't know yet how it's going to work in practice, what will be, for example, the acceptance rate for those applications, but someone is definitely keeping an eye on those new pathways, those new access regimes, which is, of course, the only way to organize a special access regime like this. But a lot will depend on who will actually supervise those pathways and the practice that will evolve around this supervision. So, I'm not wearing a tinfoil hat, as you can see. So I'm not, it's not a conspiracy theory. I'm just making you aware that there are new access rights, and the exercise of those rights is very closely monitored by national and European bodies. Thank you very much for your attention, and I am all yours for any questions that you may have.